Got it. Good morning, everyone. We're just going to take a moment while everyone gets signed in. Again, we're just giving it 1 minute while everybody gets signed in. I see the numbers rising. All right, we're going to get this started. Well, there we go. Welcome, everybody. Thanks for joining us today, December 12th, 2024, for our webinar, New Year, New Laws, Essential Updates for 2025 Labor Compliance, presented by Ethos Human Capital Solutions and Merhab Robinson and Clarkson Law Corporation. My name is Denise Keddy, and I'm your moderator for this session. And I just want to go through a couple of quick reminders before we kick off the webinar. Today's webinar will run about an hour and 15 minutes, so it's a little bit longer than usual. But if you have to leave before we're finished, don't worry. We will record the webinar, and both Ethos and Merhab Robinson have YouTube pages, and the webinar will be posted on their YouTube pages within the next 24 hours. If you have questions in the webinar, just make sure you put the questions in the Q&A box. We'll do our best to answer them at the end of the presentation. We always leave some time for questions. You can download the presentation in a few minutes. I'm going to put the links in the chat box, and you'll be able to download today's presentation so you have it for reference. If you have issues during the presentation, please put a note in the webinar chat, and I'll take a look at it. Linda has a slide link here, but we realized that there was one slide missing, so I will put the chat in the chat box, the entire presentation, so that you have the one with the missing slide. Just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today is intended for information purposes only and should not be relied on to reach a conclusion in any area of law. We recommend that you consult with your legal counsel to address your specific situation and ensure you have the most current information on legal matters, or obviously we want you to reach out to Merhab Robinson and also reach out to Linda's team if you have questions. Today's webinar has been approved for HRCI credit, and today, because the webinar is a little longer, it's 1.25 HRCI credits. If you'd like the credit, please answer the survey. There's the link for the survey. I'll also drop that into the chat box later on towards the end of the presentation. Once you answer the questions, you'll get your certificate. But today, let me kick you off our legal experts today. Our legal expert is Luna Hernandez. Luna is fairly new to the webinar team, so she's been doing this for a couple months with us. She's an associate attorney at the law firm of Merhab Robinson and Clarkson in the firm's transactional department, where she advises clients on real estate, finance, M&A, and most importantly for us today, employment law. Luna joined the firm in February of 2021 as a transactional department paralegal after she immigrated to the United States, and was admitted to the State Bar of California last year in November of 2023. And she spends any time that she has outside her office with her beautiful 5-month-old baby. And our HR expert today is Linda Duffy, President of President of Ethos Human Capital Solutions. Linda has 30 years of experience in building her business and her team to help consult, recruit, training, payroll, and organizational programs for your company. Linda and her Ethos team is known for building the magic of human connection with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so you as a business owner can focus on running your business. In Linda's spare time, you can find her cheering on. This year, it will be the hockey team. She's cheering on the Ducks because it's season. It's hockey
Duck
season.
season.
Yeah, duck season. Linda, this is our biggest webinar every year, the one that everybody wants all the information on. Can you get us started today?
I can get us started. Welcome, everybody. Happy holidays to everybody. This time as we put the slides together, Lynn and I wanted to give you some tips on really what to do and what to watch for on every slide. So if you see this little icon of a handbook, that means it's probably something you need to review in your handbook and update. And otherwise, it's a review, your policy, your practice, right? So there's some things that don't need to go into your handbook, but you still want to take a look and make sure you're being compliant with everything. We're going to really focus on two parts today, and Lynn and I are going to go back and forth on these. The first is all the legislative updates, things that were signed into law, most of them California state. And then also, Lynn is going to talk about some court cases that impact employers. And then finally, as Denise said, we always save room at the end for Q&A. So if you want to drop your questions into the Q&A section, that's great. And then we'll get to those at the end.
I'm going to interrupt you 1 second. The webinar chat isn't enabled for me for some obscure reason, so I can't drop in the
Huh.
slide handout.
Let me see if making you host makes a difference. I don't know. It
Uh,
could be a webinar function, Denise, so we'll just see
no.
what we can do. Okay,
Okay, I can do it now. So everybody, I'll
there you
drop this
go.
in. Thanks for your patience.
All right, thanks, Denise. Okay, so let's start with some legislative updates. The first thing everybody knows, minimum wage seems to go up every year. So California state across the board, right, unless there's exceptions, California state minimum wage is going to be $16.50 an hour effective January 1st. So you want to take a look and make sure everybody's making at least that amount of money, again, with some exceptions. And you also want to take a look because you're going to have some wage compression issues, right? So people that, you know, are currently at $16 an hour, maybe have worked with you for a year, and then, you know, you're going to bump them up to 16.50, but when you hire somebody tomorrow, they're going to be at 16.50. So you're going to have to give some thought to how to make sure that the people that are already there that have some experience stick around. Prop 32, we were watching really closely. Hopefully everybody knows that that did not pass, and that would have created a higher minimum wage for large employers. But at least in this election, it didn't pass, so everybody's at the 16.50 an hour. Now, as I mentioned, there are some exceptions to that. There are exceptions for different industries, so we put a few of them here. So, for example, fast food workers have a minimum wage of $20 an hour. Healthcare is at $23 an hour, and that's going to go up in July. And then also hotel workers in certain areas of Los Angeles have a higher minimum wage. So it's really important that you take a look at the definitions to see if you are covered in those industries, because fast food workers may include some things you wouldn't expect or may carve out some things that are clearly part of a national chain, but it's at the airport, for example, or something else, and then it creates an exception. So you want to take a look at all of those and make sure that you know if you're covered and what your minimum wage is going to be. And then, of course, in addition to the industry exceptions, we also have certain cities and counties throughout California that are at a higher minimum wage. So really important that you know, even if you have one employee in those areas, you want to make sure that they're being paid appropriately. So this list is actually from the DLSE website. And if you can use this URL, it'll actually you'll find a link where you can download all of the different cities and counties that have exceptions. And so that's a really good resource for you as well. And then just a reminder, you really need to audit your payroll to make sure that you're compliant with all of the minimum wage. Not just minimum wage for hourly employees, but of course the minimum salary for exempt employees. Now, just keep in mind for exempt employees, and we're talking about white collar exemptions, so the administrative, executive, and professional exemptions, that minimum salary is twice minimum wage, but it's twice the state's minimum wage. So in this case, it's twice the 16.50 an hour. So even if you have an employee, say in Emeryville or one of the other cities that has a higher minimum wage, for exemption, for white collar exemptions, you're looking at the state minimum wage. So 16.50 an hour times two times 2080 hours in a year gets you a minimum salary of $68,640 each year. Now, we always get the question about, well, what about part-time employees? Can you have a part-time exempt employee? And the answer is absolutely, but you cannot prorate the salary. So you could have somebody working 20 or 30 hours, you know, on average, And you could say they're exempt if they meet the duties qualifications, but they also have to meet that annual minimum salary. So you cannot prorate it. It's something we see all the time when we audit. We also see that people ignore the duties part and they're just like, oh yeah, we pay everybody a salary, but it's like 45,000 a year, and we know automatically they're not going to be compliant. There are a couple of other exceptions that we just wanted to highlight for you. One of those is the computer professional exemption. And this is where the duties test really comes into play, because just two parts. So on the salary part, it's a higher minimum, right? So you can see the annual salary for the computer professional exemption is 118,000 a year. So it's a lot higher than the 68,000 for the white collar exemptions. But you also, again, have to remember the duties portion. And in this case, the duties for the computer professional do not include things like help desk, right? It's not routine technical things. It's more, the work has to be intellectual and creative. There has to be a lot of independent discretion and judgment. You have to do things like, programming or software engineering, things like that. So it's not just your usual help desk. So even if you're paying your help desk people really well, you're not going to qualify under the duties portion. So just wanted to point that out. And then the other exception that we wanted to mention is about unionized workplaces. So Luna and I, neither one have a lot of clients that are union, but we have a handful. And we just wanted to make sure that everybody was aware that the collective bargaining agreement for wage and hour law exemptions, employees have to earn at least 21.45 an hour. So just take a look at that if you're union. If you're not meeting that minimum requirement for any of these exemptions, then you're going to void that exemption, and you might be liable for unpaid overtime, things like that. So you just want to make sure that you are compliant and by auditing your payroll practices. All right, let's move on to some new discrimination type bills that were passed. So this is Senate Bill 1137. And this one, I have to admit, when I first read it, I thought, okay, why do we need this? Because right now, we've all seen claims where an employee goes or a former employee goes and claims, oh, they discriminated against me based on a multitude of things, right? My age, my race, my gender, whatever. This is a little bit different. It actually includes an education part of the government code and the Fair Employment and Housing Act, and they're sort of putting everything together under one law. But what it basically says is recognizing discrimination and harassment based on multiple categories where they may intersect. So for example, you have a Black female employee who's overlooked for promotions while other women and Black men are promoted, right? And so, she might be able to come forward and make a claim for both race and gender discrimination. So I talked to multiple of attorneys about this because I was like, this seems like we already have this covered. And so one of them, I just wanted to tell you what she said back, which was some of the intent behind the law is performative, but the legislative history makes it clear that the state is trying to make it easier to bring claims for folks experiencing bad behavior on the basis of more than one characteristic. So in other words, the behavior might not be sufficiently severe or pervasive on the basis of one characteristic, but when combined with behavior exhibited because of another characteristic, it might be. So that's just the way to think about this is, the state's going to continue to try to make it easier for employees to bring claims. And in this case, it might rise to that level of severe or pervasive if they tag multiple protected characteristics. This is something that you definitely want to take a look at with your handbook. They've expanded the definition of race. And first of all, it removes the word historically, because when we talk about, and this is specific to hairstyles, when we talk about hairstyles, at least in our template up until this year, it has said historically, part of race, wearing hair in a certain manner. So this took it a little bit step further, said we're going to take out historically. We don't want any references to the past per se, because it could be something now as well. But this is, so if you have an employee that is wearing locks or braids or twists or whatever. You cannot take any sort of action against them. Don't criticize them for it, anything like that. You don't want to make references to that because it's going to be considered potentially racially discriminatory. So any type of hair, the way that it's, way that they're choosing to wear their hair, anybody, if it can be considered part of their race, then it's going to be part of a protected class. All right, the next one is Senate Bill 1100. Another type of discriminatory practice is to tell people that they have to have a driver's license in order to have a job. If the job requires the use of a driver's license, then of course that is going to be, a qualification for getting the job. And then that's fine that you can put that in ads. You can screen people based on their ability to drive because of that. But if the burden is going to be on the employer to prove that, oh, yes, this is really a bona fide occupational qualification to have a driver's license. It's not something that's just done, every once in a while, but it's really a big part of their job. You also have to show that using alternative transportation is not comparable in travel time or cost. And so you want to make sure that you don't have any requirements that are unnecessary, right, in the job. And this is trying to protect mostly immigration status, to be honest with you, because a few years ago, we had a law that said, doesn't matter if you're here legally or not, you can still go get a driver's license. And so they're just trying to make it, again, easier for employees or job applicants to file a claim if they're discriminated against based on this. So you want to make sure that you're not, your recruiters or your managers, whoever's doing the hiring, they're not putting this in a job posting unless it's absolutely a requirement of the job. Okay, this is another interesting one to me is, that we have the EEOC and we have the Department of Fair Employment and Housing, and the California Civil Rights Department, who are charged with enforcing discrimination, harassment. But based on Senate Bill 1340, now your local governments can do it as well. So I was joking with Luna, I wonder if Santa Ana Police Department's going to come knocking on my door saying, hey, you've been discriminating against somebody or you've been harassing somebody. So again, just making it easier to bring charges against somebody. I'm not really sure like why this was necessary, but it does enhance, I guess, collaboration between state and local entities to make sure that employment discrimination is as minimal as possible. And then finally, on harassment and discrimination, the EEOC actually released new guidance on harassment, which is the first time in 25 years. This was back in April. And they expanded the definitions of protected characteristics. And so it specifically includes harassment based on sexual orientation, gender identity, and gender expression. And then it also adds harassment to pregnancy-related issues. So what's interesting, though, are a couple things. One is they have, so one thing is that they've said about 70 different examples of what constitutes workplace harassment. So if you go look on the EEOC, you'll have this. You'll notice that a lot of those things are already in California law. So California typically has a higher standard, and this is true in this case as well. What's interesting to me, I started to say a second ago, is with the gender identity and gender expression, they specifically said there's something called intentional misgendering. So we've had this come up before, interestingly, although I didn't know there was a specific phrase for it, but where somebody refuses to call their coworker by the appropriate pronoun. So let's say, for example, I have a virtual assistant who's new. It's a woman. She likes they and them as her pronouns. If I were to continue to refer to her as she or her, then I could be intentionally misgendering, which could, bring about a claim against me. So we've had this before where, there are people that think, oh, this whole thing with pronouns is ridiculous, and I'm not going to do that. But it now is a potential claim. And so everybody needs to know that, train your employees, your HR department, and make sure that they're aware of this. The other thing that this new release brought up is it recognizes that harassment can occur remotely, right? It could be on a Zoom meeting or it could be via email or something like that. It doesn't have to be face to face or in person. It also goes through and says, here are all of the different ways that employers may be held liable depending on who's doing the harassing. So you want to make sure that you take a look at this update and see if there's anything in your handbook or in your practices that you need to update. Okay, and then last, before I turn it over to Luna, that there is a new indoor heat standard that went into effect last July. And we just wanted to make note of it for everybody. We're not going to go through the details. You can Google it. You can go to the CalOSHA website, and they've got a lot of handy tips. But if your workplace has a potential heat issue, and this is where an indoor temperature reaches 82 degrees Fahrenheit or greater, then you, as the employer, have to take steps to protect the workers. So that could be, providing water, cool down areas, training on how to reduce heat exposure, things like that. And then if it goes up to 87 degrees or higher, there are additional requirements that apply. So you want to make sure, again, take a look to see whether or not you're covered by this. There are some exceptions. For example, if the employee is exposed to temperatures between 82 and 95 degrees Fahrenheit for less than 15 minutes in a 60-minute period, then you're okay, unless it's a vehicle without effective air conditioning. So you got to really look at the details, the way they wrote it, to see whether or not your business is covered by this. And with that, Luna, I'm going to turn it back over to you.
Wonderful. Thank you so much, Linda, and welcome everyone. Happy holidays. The first legislative update I'm going to speak to you about today is the Freelance Worker Protection Act. And this particular act was enacted to address the unique challenges faced by freelance workers in California. The act sets minimum standards for contracts and payments in order to create a fair working environment for both freelance workers as well as employees. And some of the provisions require a written contract for all freelance work valued at $250 or more. The purpose of this provision was to ensure that there is clarity in both the terms and expectations of this freelance employment. Additionally, the Act requires employers to keep these contracts for a minimum of 4 years. And the importance of this is you want to go and have a look at your document retention policies and make sure that you're including this particular contract in those for a minimum of 4 years. Additionally, payments must be made according to the contract's terms. You must not veer from that. And if the contract for some reason does not have payment terms, you're going to need to pay within 30 days after the work is completed. Furthermore, retaliation against freelancers for asserting their rights under this act is prohibited. And enforcement of this has actually been strengthened with a provision allowing for both freelancers and public prosecutors to initiate civil actions if the act's provisions are violated. So in a similar vein to the local law enforcement, you're seeing this resurgence or rather a move towards really looking at multiple avenues for recovery. The next update is the California Worker Freedom from Employer Intimidation Act, which is an absolute mouthful. We sort of colloquially refer to this as the no captive audience law. And what this does is it strengthens employee rights by prohibiting employer coercion in religious or political discussions. So let's say you as an employer, you want to go and hold a meeting where you're going to be asserting your particular religious or political view. This protects employees against you, essentially, from doing that. The employees are similarly protected from retaliation if they choose not to attend this particular type of meeting. and there are penalties of $500 per violation for requiring employees to attend. Enforcement options include the Labor Commissioner, a complaint with the Labor Commissioner, as well as civil lawsuits, again, ensuring multiple pathways for addressing grievances. Then I believe we've spoken about this in detail before, but we just wanted to remind you that if you did not update your handbook with reference to a workplace violence prevention program, now is definitely the time to do so. This law became effective mid-year, and it requires most employers to maintain a workplace violence prevention program. As part of this plan, you're going to need to conduct a workplace hazard assessment. It has to be a written plan. There's a training requirement, both at the adoption of the plan, I believe periodically, and then certainly when you also are hiring new employees, and there are also document retention requirements. So please contact Linda if you do not have this plan. She would be able to assist you with putting this in place. Okay, new notice requirements under the workers' compensation statutes. This particular assembly bill updates existing laws related to notice requirements in workplaces under workers' compensation regulations. Employers must now include information about the right for injured employees to seek legal counsel regarding their workers' compensation rights. The thought process behind this is that it ensures employees are aware of their rights and their options to receive legal guidance. So please make sure that you are notifying employees about this, and this will require a handbook update. Next, we have got expanding occupational safety coverage. This particular Senate bill addresses workplace safety in a historically unregulated area, that being household domestic service. Currently, CalOSHA excludes domestic service, but starting as of July 1st, 2025, it will include and apply to most domestic workers, ensuring workplace safety standards for this particularly vulnerable workforce that has largely gone unregulated. Important exemptions exist here, such as publicly funded services, family daycare homes, and private individuals hiring for tasks like cleaning and caregiving. If you believe that you have employed someone that this new law will apply to, we do request that you seek legal guidance to determine whether your particular circumstances will fall within one of the exemptions or not, because if it doesn't, you're obviously going to need to comply now. This shift will require affected employers to comply with CalOSHA standards, which could involve providing training as well as protective equipment and hazard assessments. Note that the bill imposes criminal penalties for non-compliance, and this aligns with existing rules under the California Occupational Safety and Health Act. With that, I'm going to have Linda take over again to finish out the legislative updates, and then I'll jump back in with updates regarding court cases.
Awesome. Thank you, Luna. Okay, so this one also has already gone into effect. It went into effect about 3 months ago. This is called the LA Fair Chance Ordinance. And so this applies specifically to companies with 5 or more employees and doing business in an unincorporated area of Los Angeles County. Now, a lot of this bill is already in place California-wide as part of the Ban the Box law, but we also know that different cities, counties, unincorporated areas have a higher standard. So if you have employees who, I think the standard is still 2 hours of work in an unincorporated area of Los Angeles, you need to make sure that you're in compliance with this law. It actually has a lot of provisions in it. So for example, the basic one, as we all know for Ban the Box, is you cannot inquire about a criminal history before a conditional offer of employment is made. So you want to make sure you're not running background checks before you've actually extended an offer of employment. You're required to do an individual assessment based on the results. And there's also a notification and fair chance process, right? We call it adverse action process, but fair chance process. Employers are limited. They cannot go more than 7 years back. There's some exceptions to that, but you can't look back more than 7 years. And then, of course, there's penalties and enforcements as there is with all of this. So you want to make sure that you're training your HR people or your hiring managers not to ask those questions improperly before an offer is made. Make sure that you have the proper record keeping in place and that you're updating any policies or practices so you're not putting something in a job posting that you should not be. So that's the the LA Fair Chance Ordinance. Also, this is going to be in effect this coming July. Los Angeles County is going to be basically mirroring what the city already has with the Retail Fair Work Week Ordinance. So this applies to retailers and grocers with 300 or more employees globally, right? And so they define that sort of loosely as revenues that are mainly generated by sale of tangible consumer products. But again, go look at the specific definition on how they define who's covered as an employer and how they do their head count, because every one of these laws is slightly different. So you want to make sure you know whether or not you're covered. So this particular law requires employers to give their employees at least 14 days advance notice about their schedule, right? Now, what's interesting to me is there are a lot of penalties involved if you don't do that or if you make changes. So there's something that they've included called predictability pay, which is a fancy way of saying, hey, employer, if you try to change the schedule with less than 2 weeks notice, then you're going to end up paying a penalty. It's almost like a missed meal period penalty. It's paid at the regular rate. They get so much depending on what the change was in the hours and the schedule. There's a whole schedule laid out in the law. So again, you want to make sure that you're always providing a good faith estimate of the hours that are going to work. And there's rules about rest breaks in between shifts. So if you are in an industry that may be covered by this, you want to take a quick look and make sure that you're in compliance. There are also AB 2299, which is an enhanced whistleblower protection. Again, there's already whistleblower protections, in place under California federal law, the National Labor Relations Act, all sorts of things, right? So you want to make sure that you just take a quick look at this because there is a posting requirement specific to this. So the labor commissioner has the job of creating a model, right, that can be used. And there's a link there that you can take a look at. So if you use this, you're in compliance. You can also do something that's similar. You just want to make sure that it hits all the same points that are in there, but you can feel free to download that and use that going forward. But that has to be provided to all the employees. All right, paid family leave update. So first and foremost, I want to remind everybody that paid family leave is a compensation supplement benefit. It does not provide time off, right? So a lot of times employees go, oh, I'm going to take paid family leave. Well, paid family leave is money. It's not time off. So just want to remind everybody of that. So this bill, AB 2123, basically changed the rules and said that employers can no longer require employees to use 2 weeks of vacation before accessing their family leave benefits. So I don't have this come up a lot. Most employers and employees just work it out, whatever everybody wants. But we have had in our handbook template up until now that, that the company can require the employee to use up to 2 weeks of vacation time before applying for PFL benefits, and you can no longer do that. So this goes into effect for any sort of paid family leave after January 1st of this year. All right, a little bit more about workplace violence. Workplace violence, employers up until now have been able to help employees out. Let's say that, if there's been a threat of workplace violence, right? But now they can actually go a step further and employers can seek a temporary restraining order on behalf of the employee for employee harassment, right? So let's say you have a bad breakup with your boyfriend and he's continuing to harass or something like that, your employer would be able to go out and get a temporary restraining order. So there's rules around that. You have to show clear evidence that there's potential harm. Hopefully not, because workplace violence has already happened. But if it does, or if there's a threat of violence, then the company can go and get the temporary restraining order. So it pretty much just extends what was already in place to include harassment. All right, extended protections for victims of violence. So this is AB 2499, which I have to tell you is really long and very convoluted. It includes like school codes, government codes, all sorts of different parts. So the part that's really important for you guys to know, for employers to know, is that there is something now called a qualifying act of violence. You'll see it abbreviated as QAV. This is definitely something that needs to go in your handbook, and you need to update this. So a QAV, or a qualified act of violence, are things like domestic violence, sexual assault, stalking, and again, a perceived or actual threat of violence. And so this extends the protections for employees, not just if they personally suffer it, but if one of their family members has some sort of, if your family member is a victim of violence and one of those qualifying acts. And so this is now enforced by the California Civil Rights Division. So they're looking at it again under FEHA, and they're looking at it almost as like retaliation or discrimination. And so you want to make sure you're not doing that, right? Retaliating or discriminating against your employee for actually, taking use of the protections under this bill, because it'll be prosecuted that way. The other thing that's interesting to us is that the paid sick leave is now written into this bill. So it expands when employees can use paid sick leave. And even though, again, I don't understand why it's combined in this bill, it says that paid sick leave can be used for jury duty, for witness duty, and for going and doing any of a number of things on a list, like, helping somebody relocate, going to get a temporary restraining order, seeking treatment, obviously, but they threw in a whole bunch of other things. So you want to take a look at the paid sick leave provision in your handbook. And then also there is a notification provision. So you have to notify employees of their rights at time of hire, once a year, upon request, or if you find out that they are in fact a victim. So there'll be forms that are due by July 1st, 2025. So we want to make sure you're aware of this bill. The bill itself is in effect January 1st, but the forms part is going to be July. The last thing I want to mention here is you can limit the employee time off to 12 weeks. So it would coincide with CFR FMLA. So if you have somebody that's covered by one of those bills, then you can go ahead and say, hey, we're going to limit it to the 12 weeks. If it's a family member that's the victim, you can limit it 5 days to help them relocate, or 10 days total if they need other assistance. So again, the bill is very, very long, and make sure that you take a look at that or reach out to Ethos or Luna if you need additional help. But this is definitely a handbook update for you. And with that, Luna, back to you for court cases.
Wonderful. Well, the first court case we've selected today, Naranjo v. Spectrum Security Services, this is actually considered a win for employers, which doesn't happen too often in California. So I'm kind of excited to share with you what was held in this particular case. It offers clarity for employers navigating wage statement requirements and missed break premium pay. Here, the court has established a good faith defense for employers, and that is if an employer reasonably and in good faith believes that they are complying with the Labor Code Section 226's wage statement requirements, they are protected from penalties for unintentional errors. This is a critical safeguard, especially when wage statement compliance can be rather complex. The decision also reaffirmed the wage statement requirements under the Labor Code, and these include your things such as you have to list your hours worked, wages earned. There are other essential requirements. I believe the list is about 11 or 12 long, but don't fact check me on that. Non-compliance, if not based on a good faith belief, can still lead to penalties. So the bottom line here is you need to be acting in good faith, thinking that your wage statements are compliant in order to circumvent the penalties. The court also addressed missed break premiums and classified them as wages rather than penalties. The distinction means that premium pay for missed meal or rest breaks must also be included in wage statements. It must be reported accurately and paid with final wages if an employee leaves the company. Employers who knowingly and intentionally fail to provide compliant wage statements can face fines ranging from $50 for an initial violation to $100 for subsequent ones, and this amount is capped at $4,000. Final wage payments must now include the missed break premiums, and this reinforces the importance of precise payroll practices to ensure all wages, including premiums, are handled correctly at termination. So generally speaking, if you have engaged a payroll company, I feel like employers sometimes just assume that their payroll is being done correctly and that these wage statements are compliant. I would urge you to either yourself or with the help of Ethos or our firm, conduct a mini audit on your payroll pay stubs and make sure that they've got everything in there that they need to. Next one is Huerta v. CSI Electrical Contractors. And this case really concerned compensable working time. The court first held that time spent at an employer's security gate awaiting or undergoing vehicle inspections, which include visual checks and are employer mandated, must be compensated as hours worked. This finding reinforces the idea that employer control during these security check procedures makes the time compensable, so you need to pay them for this. Secondly, the court held that when it comes to general travel between a security gate and a parking lot, that time is not compensable merely because an employer imposes general workplace rules during the commute. So employers' rules such as adhering to the speed limit or adhering to employer anti-discrimination policies, they do not create a sufficient level of control to make that travel time compensable. Small win for employers on that second point. The third major point involves meal breaks. While a collective bargaining agreement can exempt certain industries from specific meal period regulations, the court ruled that employees must still receive at least minimum wage during meal breaks if they are prohibited from leaving the premises. This applies when the restriction prevents employees from engaging in personal activities that they could do if not confined to the work site. And lastly, the court addressed employer-mandated travel that is unique to Wage Order 16. And as a reminder, Wage Order 16 covers industries like construction and mining. Travel time between a security gate and parking lot is only compensable when the location requires the employee's presence for a work-related reason beyond simple site access. So if you have any questions regarding is getting from point X to point Y compensable and you want to have a look at this case, this will provide some insight to you. If we could go to the Hasty v. AAA slide. This particular case, an employee sued the employer for discrimination, harassment, retaliation, and wrongful discharge. Employer moved to enforce an arbitration agreement, and as part of the findings, the claims that the employee was making, she said that she had electronically signed this arbitration agreement on her phone at the time of her employment. And in reading the case, she was even arguing, it was the smaller iPhone 6 model with the smaller screen. It went into that particular type of detail. Here, the court found that the arbitration agreement was both procedurally and substantively unconscionable, and this led to its unenforceability. It found that the agreement was difficult to read and it was dense when viewed on a mobile device, with no alternative means of presentation offered to the employee. Additionally, the signature statement was vague and it didn't specify what document was being signed, obviously creating ambiguity. It included one-sided provisions such as hidden waivers of rights, confidential arbitration clauses, and a waiver of representative claims, which conflicts with California law. So what does all of this mean for employers? To ensure enforceability of your arbitration agreements, you need to maintain transparency and consistency throughout your onboarding process. So this is a place where you really want to be reviewing your onboarding procedures and making sure that if and when you are presenting arbitration agreements to your employees, they are meeting the standards set by California law, but also by this case. Specifically, your agreements should adapt to be legible on various devices, provide alternative options for reviewing documents, and ensure that third-party software complies with California's transparency standards. When you are crafting and presenting your arbitration agreements, it is important that you prioritize clarity and fairness to avoid issues of unconscionability and ensure that these agreements hold up in court. The bottom line is make sure employees are reading your arbitration agreements. You want them to read these arbitration agreements, and it is best practice to get a wet ink copy of the agreement. We have not included a case here, but I did just want to highlight something. It is called Cook v. USC, the university, and it similarly dealt with both substantive and procedural unconscionability. The bottom line here is also have counsel review your arbitration agreements and procedures. And the very last case that we're going to discuss, a short one and not quite as mouthful as the ones before, is this particular case where the decision underscored the importance for employers to ensure that arbitration agreements are explicitly renewed or reaffirmed upon rehiring of former employees. Relying on prior agreements without clear reestablishment may leave disputes arising from subsequent employment periods outside of the scope of arbitration. So you can see on the slides here, it just gives you a bit of procedural history. There was an employee who had signed an arbitration agreement. She then resigned and then was rehired, and the employer was attempting to assert that her claims would be subject to arbitration because of the former arbitration agreement that she had signed. And the court said, no, this is not going to happen. It will not be applicable in this case. There is another case. I missed that last one. Sorry about that. I believe that this is our last case before I tell you a few action items. So in Bailey v. San Francisco District Attorney's Office, the California Supreme Court clarified that even a single racial slur can lead to employer liability for harassment if viewed from the targeted employee's perspective. The court emphasized considering the totality of circumstances, including informal workplace power dynamics. The court here highlighted that retaliation doesn't need to be tied to a specific adverse employment action. It can be shown through a pattern of behavior, pervasive behavior that impacts job performance. The key takeaway from this case is you need to take all harassment complaints very seriously and respond promptly. Ensure that both your managers are trained as well as all of your senior level employees to recognize and address harassment as it happens. And in general, go about your business creating an environment of respect and accountability. And with that, I now have some action items for all employers. Firstly, it's a good time to audit your payroll for compliance with state and local wages. If you have exempt employees' salaries, you need to make sure that they're going to meet the new minimum threshold, which Linda had discussed with you. This is the time to update your employee handbooks for the new year. If you engage freelance workers, if anything is over $250, you want to make sure that you have a contract in place. And if you need a form contract, reach out to us so that we can draft you one. And also review your onboarding with respect to arbitration agreements and driver's licenses to ensure that you're only requiring driver's license as permitted by law. And with that, we are done and the floor is open for some questions and hopefully we can answer them.
Went a lot faster than we anticipated, so that's good.
Yeah, I'm going to drop now into the chat the survey so that everybody has the survey link for HRCR credits. Before we get into any questions, we just want to make sure that we cover, we're always looking for topics for webinars. So if there's any questions you have or things you'd like to have covered in a future webinar, we're building out our calendar for next year. So we would love to have your input. If you want to just drop it into the Q&A section, I'll make sure we take a note of it. Um, who
And
wants?
to
Yeah,
that point, we
yes.
do have our next webinar scheduled, which wasn't in the slides because we just made the determination last night. But our next webinar is going to be on February 12th at 11 a.m. And we're going to focus on the good old topic of discipline and discharge, because that's always a winner. We get a ton of questions. A lot of people show up for that one. So we decided to do that one again. But to Denise's point, if you have other topics, we'd love to deliver a webinar on it. The hardest part for us is coming up with the topic, not the delivering of the webinar. So anything you want to know, you just let us know and we will put it together for you.
Yeah. And apparently the survey link that I had wasn't working, so I'm redoing it and putting it
There'll be
in.
a follow-up email for people in attendance, Denise, and it has the link in there. So
Okay. I just dropped it in and it's working this time. It should be.
perfect.
So a couple questions are rolling in right now. We know we covered a lot of information. And first and foremost, make sure that you take down Linda's number and Luna's number because I know everybody sits through these webinars and think they understand everything. And then when you start getting into the policies, there are a lot of questions. So make sure that you reach out to Linda and Luna on any of your questions. We have a question. Can you shed some light on current protections for sales compensation for sales employees and sales leaders?
Some protections. I don't understand the
Yeah.
question.
Yeah,
I
me
don't.
neither.
Okay. So maybe the person, I don't want to give their name out, will
Well,
send us another
I'll,
update.
I'll just say this. The last webinar that we did actually was on compensation and exemptions for sales professionals for indoor and not inside and outside sales, not indoor. That's the heat. Anyway, for the inside and outside sales. So the rules are different for compensation for inside sales and outside sales. So go out to youtube.com/ethos HCS, just like the predicate in my email address, and you'll find the webinar out there. Take a look at that. If that doesn't answer your question, then just reach out to one of us since we don't understand the protection word in that question.
Yeah. Quick question. And I don't know if we've ever considered this, but will you offer SHRM credits for future webinars?
Great question. So let me address that. They charge us, right, to be able to offer webinars and get credits for everybody. So because I have both, but I will just tell you this, you can still get SHRM credit. The only difference is like when you attend and we give you the HRCI credit and the certificate, the number pre-populates, right? If you go into where you have to put in your continuing education credits, you put in that number, it puts in, oh, this was by Linda and Luna on this date and all that kind of stuff. That's really the only benefit to you guys. So if you attended today, you just listed under your SHRM as attended with the topic, the date, and the presenters or whatever the information is, and you'll still get credit. So even though it's not pre-approved, you can still get credit for it.
Great. So we talked a little bit about the heat and we didn't get into the details of the heat. I know
Yeah.
we talked about that, but is there requirements for cold?
I don't know of any requirements for cold weather. Do you, Luna?
No, not off the top of my head. That's an interesting question. Might
Yeah.
lead to some research after this.
Yeah, exactly. I mean, you could Google, you could go out to the Cal OSHA website and see. I don't know of any. I've never heard that, but in California, I guess there's certain parts where it would get cold, but usually not in Southern California.
Yeah. So we have a question on job postings. Job postings on Indeed must check the box yes or no if you encourage applicants with criminal records to apply. Do
Yeah.
California employers need to check the yes box because of the Fair Chance Ordinance?
Yeah, great question. So the short answer is probably,
Mhm.
right? The longer answer is there are going to be some exceptions, right? So let me hallucinate one. Let's say you're hiring and you're going to work on federal property and you have a drug conviction or something like that, it may preclude you from allowing that person to work there. If that's your only job opening and they don't qualify based on that, then that's one thing. Or if there's some sort of standard under a contract, right, with the government that they may say, we're not going to allow anybody with a certain type of conviction or any conviction to work here. They're getting fewer and fewer. So in California, it's really hard to say we can't hire a felon, right? What you have to do is that individualized assessment. So you have to take a look at the recency, the nature of, the conviction and how it relates, the relevance to the position. So another example is you wouldn't have to hire a pedophile to work at a daycare center, right? You wouldn't have to do that. But you wouldn't be able to just check a box that say we don't hire felons, right?
Mhm.
Because it could be something else that they did that wouldn't preclude them from working there. Luna, anything you want to add to that?
No, perfectly said. I agree 100% with you.
Okay, oh wait, we have another question that just came in. What kind of documentation would you suggest to send for an exempt staff that are being bumped up to the new minimum threshold?
We just use an internal payroll status change form usually. So just, take people from this pay to that pay. So that's usually all we have. If you want to reach out, I'm happy to share a sample form with you, but we usually have a payroll status change form for any of those type changes. Somebody's title changes, somebody's something changes, right? And you just put the sort of before and after in it. So that's all I would do. You could, just send it memo form too if you want. Obviously keep it confidential because it's money, but other than that, I would just do that.
Okay, great. And I see a couple questions that are more specific. And like we said, if you have a very specific question, you should reach out to Linda or to Luna directly. The information is right on our screen. And I think we're done with our questions for today. So
Wow. We
I know
absolutely got
that's
done on time. So if anybody
unusual.
asks, this went until 12:15, so you get 1.25 hours of credit. So it's like personal study time now for the next 15 minutes. So
Right, to go back and read the slides so that they can understand what's going
exactly.
on. So, but thank you for setting this up, Luna and Linda. I know that this is an important webinar every year because every year there's a whole spate of laws that people need to understand, and it's the end of the year, and everyone's cramming to get everything set up for next year. So we appreciate your time today.
Thank
Thank you
you for
so much.
attending.
Nice to
Happy
be here.
holidays.
Take care.
Happy holidays.